I'm going to go off now.
Good morning, everybody. We're going to get started in just a second. We're letting the people that wanted to see this live come in, and then we'll get started. It's only going to be about a 20-minute overview, but I'm going to set you up for what we're going to be doing in about a week or so. And yes, we are recording this, so just so you know. And let me get a few housekeeping things out of the way. You can edit this out if you'd like for the recording, but what I'd like you to do, those of you, there's a lot of you, 155 people so far, more now. You're going to have questions. I know you're going to have questions. And what I'd like you to be able to do is send those questions, and I'll give you a couple of email addresses. And Lori, if you could put yours in the chat room as well. And Brenton, we're going to get these questions, and then next week we're going to start answering them. So, but I only have a couple of minutes today, so let's I'm going to go ahead and get started if that's okay with everybody. So what we're going to do today, this is my standard rant. I do it every month. And what we usually do is just go over a hot button topic, but we were asked today to kind of give you a brief overview of what's going on with the settlement. And frankly, it changes every day. We just heard this morning that another major brokerage settled, Compass settled for $57.5 million, which now brings the total, including what NAR is going to contribute, up to about $650 million. And obviously there'll be more to come. It's a very complex document, the settlement agreement. There's about 108 pages worth of information. So I'm going to try and break it down for you really quickly and go over the things I think you're the most interested in, which is probably the practice changes. First of all, it has to be approved by the court. So don't let anybody tell you that this settlement is now concluded. It's not. It is still to be determined, and it's probably going to take several months before we actually have a final resolution. It's broken up into a couple of component parts. The first part has to do with all the procedure, and I'm just going to touch briefly on that. If the court approves the settlement, CAR, NAR, CRMLS, and every association and its members will be released, and that's assuming that the judge approves that. All the lawsuits, you probably heard there have been somewhere near 24 copycat lawsuits are being settled. There are some opt-outs. There's going to be challenges, obviously, to some of this, because some of the lawyers who thought they were going to have an enormous payday are in fact not going to have an enormous payday. A number of brokerages have yet to settle. The big ones, the ones that did over $2 billion in 2022, some of them are now settling, and they'll have some time to do that. Non-NAR MLSs, so these broker-owned MLSs or these internal MLSs, are not settling either at this juncture, although there is a pathway to settlement in the agreement. Financially, NAR is going to pay $418 million over a 4-year period. It is incredibly complex. There are pages and pages and pages of how that's going to take place. There'll be about $100 million that'll be paid out this year, and there'll be notices given and all kinds of important information. But let's talk about what you guys are really probably interested in. There's going to be some significant practice changes. Now, I want you to listen to this very carefully. Number one, as I said, hasn't been approved yet. So we've got to make sure that the court will approve it. And I'm not a betting man, but if I were, I would bet that this is going to get approved, because this is exactly what the Department of Justice and the Consumer Federation of America have been pushing for a very long time. Number two, assuming that everything does get approved, nothing is going to go into effect until the middle of July of this year. So you've got all the rest of March, April, May, June, and the middle of July to get ready. And in talking to the presidents of the boards and talking to the CEOs, you're going to have more information than you're going to know what to do with. What you need to do is to pay attention. The fact that you're here today on such short notice is a wonderful compliment to you and to your people, that you really are interested in this. And so it's very, very important that you pay attention to what's being offered, to what's being written. You're going to be inundated with information from NAR, CAR, and the association, and that's where you need to listen, and the MLS. That's who you need to listen to. Don't be listening to all this nonsense that's going on out in the social network world. Don't be listening to those kinds of things, because there is so much misinformation, so much hyperbole, so much emotion. It really doesn't serve you. You need to listen to what the board is telling you, particularly what CAR puts out and what the MLS puts out. And I talked to the MLS attorney just yesterday, and they're planning on all kinds of information. So is the association. I was told this morning there's going to be multiple and lengthy classes. So that's where you need to pay attention. First thing, and I think this is a good change. You are, in order to participate in the multiple listing service on the buy side, you will have to have a written agreement. Now, CAR is working to update its buyer broker representation form. They're going to be updated and will be available sometime in May or June, although they won't be issued until late June. You're going to have a good form. It's not the only one you can use. There's going to be others. There's going to be internal forms, but I like the CAR form because it is very, very thorough. And that form, along with all the other forms, just like what happened during COVID, if you remember, CAR did a great job of pushing out forms on a regular basis as the law changed, as local jurisdictions took it upon themselves to expand landlord-tenant protections, all that kind of stuff. So keep an eye on what Pacific West, Tri-Counties, anybody else is pushing out to you, because that's going to be where the real information is. So there's going to be a mandatory buyer broker representation type form. Also, there's a bill before the legislature that will, and I'm going to go into this in more detail next week when we have a longer meeting, but there's going to be a bill that's going through the legislature right now that will also make it mandatory at the state statute level. That means that the Department of Real Estate and the state legislature and all that will be working on that. It's going to be a lot of new and revised forms, not just the BRBC, but all the ancillary forms. There's going to be a couple of new forms coming out in June. They're going to look at the residential listing agreement and make sure that it's current and that the sellers are given the same basic transparent information that you're going to be giving them on the buyer side. So all that's going to be done, and we're going to be busy. You know, myself, Lori, Brenton, all the staff at the association, Laura, everybody's going to be so busy that it's going to be incredibly important for you to keep up and to listen to what we're telling you. But for those of you that are already using a BRBC, I think you're going to be in much greater shape. All of the references to mandatory offers of compensation. Right now, the way it works, you put a listing in the MLS, you offer some amount of compensation, and the buyer's broker will then show you the house. And if in fact a deal gets done, then out of the listing broker's commissions, there will be a split of whatever is agreed to, and all that's going to be gone. It's all going to be a matter of negotiation. That's where the real training is going to take place, because we're going to give you all the information on how those negotiations take place, how the seller can make offers of compensation in the form of concessions, just like they do right now with things such as repair credits or buying down of interest rates, or all the things that you guys do now. So be aware, we're going to go into a lot of depth, and I'm going to tell you about a program coming up next week where we're going to dive really deep into that particular issue. Because in terms of the questions that are coming in, that's where most of the questions have been focusing on. But we're going to talk about lender issues and all the things that are going to happen next week. We're going to talk about all that next week. But all of the fields of any kind that refer to the listing broker making offers of compensation are going to go away, and it's all going to be seller generated directly to the buyer and or the buyer's broker, and it will be all subject to negotiation. And that's going to be the big change that's going to take place for most of you coming up in mid-July. There's going to be a very broad field being created right now that will be pushed out to you in the near future on how this concession field is going to work. But the elimination of broker compensation is very broad, and for all intents and purposes is gone. All sources of money that the brokers are going to make are going to have to be very precise, very objectively verifiable. In other words, you're not going to say, you know, certain ambiguous things. You're going to be pretty precise. In other words, I need to know as the consumer what you're being paid, what exactly you're getting from me. If I'm going to give you some money, what you're going to get from the listing agent and or the seller, in whatever manner that's going to work, and it's going to have to be very precise. There are some things that I don't think I agree with, but it doesn't really matter, that will limit how much you can make, not in terms of the actual money, but for example, if you agree to a $25,000 fee, you aren't going to be able to make a bonus over that without going through a lot of hoops. And so we'll talk about that a little bit next week. Again, there's going to be a bunch of new forms. What you should be thinking about now and maybe talking, and we're going to provide you some information next week and then over time on how you go about making these presentations, because here's the number one thing you need to understand. You're worth it. You're going to charge me to sell my house X amount of percentage. You're not going to charge, you're not going to be told, and above all that, you're going to pay an additional percentage that's going to go to the buyer's agent. On the buyer's side, you're going to work out directly with the buyer how you're going to get paid, whether it's going to be from the seller, whether it's going to be from personal income that I have over and above what my purchase price is, or how that's going to work out. And there's an awful lot that I'll go over with you next week about what the lenders are talking about, what Congress is talking about relative to lender-related issues. Those of you that understand your value and can verbally present your value, I think are going to be just in great shape. We're going to tell you about some sources where you can take a look and say, oh yeah, I do that, I do that, I do that. And there's about 284 of those things referenced, and you're going to be able to then say, you know what, I really do have value, and I'm not going to be ashamed to say I want to be paid. No one is expecting any of you to work for free. Whether you make more money, whether you make less money, a lot of that's going to depend upon your business acumen and how you are going to be able to present yourself. But you're going to need to pay attention to what's being pushed out and seeing how things are working. One of the things that I want to talk about next week, and I want to talk about it now, is I've been hearing a lot of talk, scuttlebutt, if you will, about how some agents are going to try and get around some of these rules. Don't do that. That's going to get you in a lot of trouble, a lot more trouble than you can imagine. So the rules, once you understand how it's going to work, are not going to be that complicated. I wish I could stress that to you enough. Commercial brokers have been doing it this way for a very long time. Obviously, it's different for commercial than it is for residential. But I want you to understand that this is not the end of the world. This is just a new way of getting paid. All the rest of the transaction, for the most part, is going to be exactly the same. There's not going to be a lot of great changes. We'll talk about some of that down the line. There's probably going to be some significant changes to the multiple listing service rules. There may be some changes depending upon what the legislature does to some of the Department of Real Estate rules. I'll go over all that with you next week. We'll get a much clearer picture. And then, frankly, as we move towards a settlement, towards resolution, towards resolving all the different arguments that are going to be made, and move on into May and June, we're gonna be able to start giving you very specific bite-sized ideas on how you can deal with all this. So please don't panic. Some of the stuff you're already doing. For example, the settlement requires that you no longer be allowed to advertise your services as free. Well, guess what? Your MLS has undertaken that a long time ago. You cannot advertise your services for free unless you're truly working for a relative or a church or a friend or something like that, and you're basically doing it pro bono, no money from either side. Number two, you're going to be not able to search by compensation only, but your MLS took that out a long time ago, so that's not really going to be an issue for you. So again, don't worry about that because you're already doing it and you're already fairly transparent. So what's going to be happening is we're going to have to figure out what the changes are going to be to all the forms. And CAR's group, as I was told yesterday, is going to be working on all that over the next month or two. They're going to have to make some changes to the compensation, the VRBC compensation agreement. They'd already made a whole bunch. There's going to be a matrix, for example, similar to the matrix you guys have in the RPA. Going to be a matrix on pages 1 and 2 of the BRBC form. There's going to be some language changes, and we'll go over all that with you. There's going to be some ancillary documents. There's going to be a brand new form, which is a commission advisory you'll be able to hand out, which is going to lay out in much more detail how the buyer is going to be responsible for and how commissions are going to be paid to the buyer's agent. That's going to, I've taken a look at that form. It's outstanding. There's going to be a couple of changes to the RPA to make it easier to negotiate for commissions inside the RPA. There's going to be some changes to the CBC form, the Cooperating Broker Compensation form. There's going to be some changes to the listing agreement. And again, all these changes will be highlighted in newsletters, in live classes, in Zoom classes, any way that the board feels it can get information out to the most people. What we need from you guys are your questions, right? I'm just a lawyer. The board is made up of very top-notch real estate professionals, and they have their own questions, and then frankly have been sending a lot of information and asking a lot of very good questions. But we don't have all the questions and we can't read your mind. So if you have a question, here's what I want you to do. I want you to send it to the association or to me. And let me give you my email address. You can send it to either myself, and that's JVG at Tyler Law, TYLER Law, LLP.com. Again, JVG at Tyler Law, LLP.com.